testifies presiding. Please make sure your cell phone and electronic device are turned off. If you don't, you want to call you in session. You may be seated. Good morning, Your Honor.
Thank you. Good morning. Good morning, everyone. If the attorneys would please place their appearances on the record.
Christina Stifler, Alan Mizrahi, Stephen Siegel on behalf of the state.
James Hill, Jesse Dreiser, Jenny Nepstead, Shannon Day on behalf of Fernandez to my immediate left.
All right, thank you. Good morning. Just for the attorney's benefit, I went over the instructions, and for some reason I compared the reasonable doubt instruction to the standard. It was like way off, and so I just went and recopied the whole standard. It had extra words in it, so I just copied the standard. So that was a major change from what we discussed before. I'm going to join Zoom. Everyone can be seated. I'm going to join Zoom, and then we'll get started. It's connecting still. Oh. Mike, are we good?
Yes, ma'am.
Okay.
When you're ready to share screen.
Can you maximize it, please? It's not going to shift, is it? Okay, good. Is everyone ready?
Yes, Your Honor.
All right, let's bring in the jury. Thank you. All right, good morning. Welcome back. Everyone may be seated. All right, members of the jury, just to remind you where we are, all the evidence is closed. The attorneys yesterday gave all of their closing arguments, and this morning are the instructions on the law. So as I don't know if you recall, it's been a while ago that I explained during the preliminary instructions, I asked that you just listen to the instructions, and the final instructions that are more technical in nature, the law of this case, are going to be published to you, and you should see those on your screen. Does everyone see those? If you can answer out loud for me. All right. And so before we begin, I just want to confirm that everyone followed the communication rules over the night's recess. If you could answer out loud. Okay. Now, before I begin the reading of the final instructions, as you can see on this page that I'm showing you, there's a place for me to sign my name. So once I'm done reading, I'm going to file this copy. I'm going to print it out, obviously, and you'll have a copy of this while you deliberate. I'm going to file this copy at the end, and the reason why I'm pointing this out is because I'm going to also give you a working copy. Okay, the working copy is going to be double-sided to save a couple of trees, okay? But it will have all the same instructions, but it will be watermarked working copy. You all can do whatever you want with that working copy. You can choose not to use it. You can mark it all up. I do not want you all to mark the final copy that you see because it's going to have my signature on it, and there's no way for me to kind of replace that after I read it. So I don't want you all, and the reason why I'm pointing it out, your notes are all going to be destroyed at the end. So I don't want you all to inadvertently make this copy that I'm filing in this case a note document. Do y'all understand that? Okay. All right. So with that explanation, I'm going to begin the reading of the final instructions. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Mario Enrique Fernandez Saldana, the defendant in this case, has been accused of the crimes of first-degree murder and solicitation to commit a capital felony. As to count one, to prove the crime of first-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, Jared Bridegan is dead. 2, the death was caused by the criminal act of Mario Enrique Fernandez Saldana. 3, there was a premeditated killing of Jared Bridegan. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. As to count one, if the evidence does not convince you that the defendant committed the main crime of which he is accused, there may be sufficient evidence that he committed a lesser included crime. In other words, if you decide the main accusation has not been proven beyond a reasonable doubt, you will need to decide if the state proved beyond a reasonable doubt that the defendant is guilty of a lesser included crime. The lesser included crimes of first-degree murder are second-degree murder and manslaughter. As to count one, to prove the lesser included crime of murder in the second degree, the state must prove the following three elements beyond a reasonable doubt. 1, Jared Bridegan is dead. 2, the death was caused by the act of Mario Enrique Fernandez Saldana. 3, there was an unlawful killing of Jared Bridegan by an act eminently dangerous to another and demonstrating a depraved mind. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and indicates an indifference to human life. To convict of murder in the second degree, it is not necessary for the state to prove the defendant had an intent to cause death. As to count 1, to prove the lesser included crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, Jared Bridegan is dead. 2, Mario Enrique Fernandez Saldana intentionally procured an act that caused the death of Jared Bridegan. To procure means to persuade, induce, prevail upon, or cause a person to do something. If you find that Mario Enrique Fernandez Saldana is guilty of manslaughter, you must next decide unanimously and beyond a reasonable doubt if Mario Enrique Fernandez Saldana used a weapon as a principal during the course of the manslaughter. As to count 2, to prove the crime of criminal solicitation, the state must prove the following 2 elements beyond a reasonable doubt. 1, Mario Enrique Fernandez Saldana solicited Henry Tenon to commit first-degree murder. 2, during the solicitation, Mario Enrique Fernandez Saldana commanded, encouraged, hired, or requested Henry Tenon to engage in specific conduct which would constitute the commission of first-degree murder or an attempt to commit first-degree murder. It is not necessary that the defendant do any act in furtherance of the offense solicited. To solicit means to ask earnestly or to try to induce another person to engage in specific conduct. If the defendant helped another person or persons commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did. If the state proved beyond a reasonable doubt, 1, the defendant intended the crime to occur, and 2, the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit the crime. To be a principal, the defendant does not have to be present when the crime is committed. The following instructions apply to count 1 of the indictment. For first-degree premeditated murder, the state must prove the defendant intended that the killing of Jared Bridegan occur. For the lesser included crimes of second-degree murder and manslaughter, it is not necessary for the state to prove the defendant intended the death of Jared Bridegan. It is not necessary for a principal to know every detail of how a crime will be committed. As long as the principal intended the crime to occur and did some act or said something that was intended to help and did help the crime occur. To be found guilty of the lesser included crime of manslaughter with a weapon as a principal, it is not necessary for the state to prove a defendant knew another participant of the manslaughter would be armed. As to count 1, the state must prove that the crime was committed on February 16th, 2022. As to count 2, the state must prove that the crime was committed on or between November 1st, 2021 and February 16th, 2022. The state must prove by a preponderance of the evidence that the alleged crimes were committed in Duval County. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not proof beyond all doubt. A mere possible, speculative, imaginary, or forced doubt is not a reasonable doubt. Such a doubt is not a guess or mere conjecture. Rather, it is a doubt based upon reasoning and common sense after careful and impartial consideration of all the evidence in the case. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If, after a careful and impartial consideration of all the evidence, you have a reasonable doubt as to the guilt of the accused, it is your duty to find the defendant not guilty. On the other hand, if, after a careful and impartial consideration of all the evidence, you are convinced beyond a reasonable doubt that the defendant is guilty, it is your duty to find the defendant guilty. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has a witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Has the witness been convicted of a felony? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in the case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did not take the witness stand to give testimony in the case. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you've heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. During this trial, I've permitted you to take notes, and you will be allowed to take those notes into the jury room during deliberations. You are instructed that your notes are a tool to aid your individual memory. You should not compare your notes with those of other jurors in determining the content of any testimony or in evaluating the importance of any evidence. Notes are for the note-taker's personal use in refreshing his or her recollection of the evidence. Notes are not evidence. Above all, your memory should be your greatest asset in your recollection of the evidence. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you, and they are as follows. Members of the jury, I'm going to explain these verdict forms to you. There are two of them. Okay, so I'm going to read the information that is on the verdict form. If it is repeated, I'm not going to reread it to you because these are forms, okay? So starting in the upper right-hand corner, it reads, in the Circuit Court of the 4th Judicial Circuit, in and for Duval County, Florida. It has a case number and then the division. Moving to the left-hand style, that's the style of this case, it reads, State of Florida versus Mario Fernandez Saldana, defendant. That is all the same, so I'm not going to read that on the second form. Moving to the title of this form, it reads, Verdict Count 1. Going to the next line, it reads, We, the jury, find the defendant guilty of first-degree murder as charged in the indictment. If that is your verdict, you would check that line. The next line reads, We, the jury, find the defendant guilty of second-degree murder, a lesser included offense. If that is your verdict, you would check that line. The next line reads, We, the jury, find the defendant guilty of manslaughter, a lesser included offense. If that is your verdict, you would check that line. If you do check that line, you move to the following line, which reads, If you find the defendant guilty of this offense, you must choose one of the following findings. The line under that reads, We find the defendant as a principal did use a weapon during the commission of the offense. If that is your factual finding, you would check that line. The next line reads, We find The defendant, as a principal, did not use a weapon during the commission of the offense. If that is your factual finding, you would check that line. Moving to the next line, it reads, we, the jury, find the defendant not guilty. If that is your verdict, you would check that line. The signature line on this verdict form is on the second page. So starting with the first line, it reads, so say we all, which indicates a unanimous verdict done at Jacksonville, Duval County, Florida. Again, the jurisdiction of this court, and it has a place for the foreperson to sign and date. That is the same on the second form, so I'm only going to read that once. Moving to the second form, title reads, verdict, count 2. The line under that reads, we, the jury, find the defendant guilty of solicitation to commit a capital felony as charged in the indictment. If that is your verdict, you would check that line. The next line reads, we, the jury, find the defendant not guilty. If that is your verdict, you would check that line. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crime charged. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict and bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror leaves the room, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you've reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as email or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I've given in this case, you must tell me by giving a note to the bailiff. Many of you may have had cell phones or other electronic devices during recesses. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. The devices will be guarded by the bailiffs while you deliberate. If you need to communicate with me, send a note through the bailiff signed by the foreperson. If you voted, do not disclose the actual vote in the note. If you have questions, I will talk to the attorneys before I answer, so it may take some time. You may consider your deliberations while you wait for my answer. I will answer any questions if I can in writing, but generally speaking, I will do it orally here in open court. During the trial, items were received into evidence as exhibits, and you may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules that we all share. Members of the jury, that concludes the reading of the jury instructions. I saw about 2 typos that I'm going to fix before I print them for you, okay? Let me see the clerks at sidebar. All right, sorry about that. So a lot of coordination, a lot of moving parts. Okay, so now that the final instructions have been read, in in a case like this, there are 12 deliberating jurors, and so that you know that there are 16 of you. And so 4 of you have been serving as alternates in the case. Before I tell those jurors who they are, let me explain why we do it. So just as serious as if you all had failed to follow the communication rules, this court must have 12. I can't have 11, I can't have 10, I can't have 7, I can't have 6. There must be 12. And so I try a lot of cases, and this is not a hypothetical situation that I'm telling you about. Sometimes there are unforeseen circumstances where jurors have experienced emergencies, and if we fall below the required number, I'd have to declare a mistrial. This entire trial process would have to start all over. And so I'm explaining that to you because, number one, you all know how hard that you all have worked. Number two, you know what great lengths that we went to have you all and get finality in this case, getting it to the jury. So in my mind, the alternate jurors serve in such a great capacity to get us finality in the case. And while they do not deliberate, okay, they serve as important members of the jury panel. And so I was written one time by an alternate. He's like, why was I the alternate? So I was like, okay, I got to explain why. So the way that we go in the process, the lawyers select in order. And so the jurors that are selected with the higher numbers, because you know you were seated, are jurors numbers 77, 82, 83, and 85. You all have been serving as alternate jurors, okay? And before I give you a huge thank you and excuse you from your service, let me ask, do you have any personal items in the jury room? Yes? Okay. If you would go with Mr. Holman momentarily and collect those items and rejoin me, I have some parting instructions for you, okay? So if you could do that now, please. Thank you. Please let the record reflect that the alternate jurors have gone to retrieve their personal items. Members of the jury that will be actually deliberating in the case, let me remind you, consistent with the final instructions, okay, first order of business is to select a foreperson. We're going to be waiting. We're going to be gathering things. I'm going to have the attorneys check and make sure that all the exhibits that have been admitted will go back to the jury room. So it's going to take us some time, but during that time, we need you to buzz that buzzer, okay, and let us know that you have selected a foreperson. You cannot begin your deliberations until you've gotten the instructions on the law that I've just read and also the exhibits and evidence. Does everyone understand that? If you can answer out loud. All right, so first order of business is going to be to choose a foreperson. You're going to buzz, and then we'll be right with you. You can refresh yourselves or do whatever you need. And then when you get those items, that is the law and the evidence, Mr. Hathaway will come out, and he'll call the deliberation time. Does everyone understand? Okay, so it looks like, where did Mr. Holman go?
It's all based in the hole.
All right, did they get there?
Yeah, they get it.
Okay, so they can come back. All right, thank you. Members of the deliberating jury, if you all would please retire to the jury room to select a foreperson. Bring your notes. Okay, thank you. May the record reflect that the jury has left the courtroom. Everyone may be seated. Remember, alternate jurors. Okay, so let me explain. That's the worst part of my job, okay, which are telling like fabulous, awesome jurors that they're the alternates. I probably make this up in my mind that you're like, I don't know what scale you fall on, if you're like super bummed that you don't get to deliberate or you're relieved and you're like, good. Thank goodness I can go about my life again. But you don't have to tell me where you fall. but this is what I do want to tell you, which is first and foremost in my mind is on behalf of both sides, thank you. Okay, I don't think that we can say it enough or express it enough. You all have sacrificed a tremendous amount of your time. You've served your community in such a great capacity, even though you're not deliberating. And I sincerely mean what I'm saying to you, okay, which is to get this case to this point, to get finality in this case, you all have performed such an incredible service. And so a couple of things. The communication rules that I put into place, they're not now lifted. You can look up, you can research, you can choose to go on about your life and not do any of that, okay? So all those prohibitions that I put into place, those are all now lifted, okay? Additionally, as serving jurors, I put in an order protecting your identity. They will, at some point in time, I believe, tell them we'll be right with them. At some point in time, the order does release information that is pursuant to statute 60 days after this verdict. So you need to know, and I'm going to tell them that people may reach out to you at some point. They may not. I don't know. But you need to know that I did put an order to protect your identity. You are only known by juror number. Number two is that if you choose to talk about this case or not, that's going to be left up to you individually. You can preserve your privacy as a juror. There is no requirement by law that you communicate or talk about your service. You can remain completely private, or you can waive it and you can talk about it. Okay? Do you all understand me? All right, so I'm going to go print these instructions really quick. If you are curious about what happens with this case, I'll give you my office contact, my judicial assistant, Miss Wilk. You can call her, let her know that you were the alternates on the case, and you can ask her what occurred. If you choose to, she's not going to ask you any questions. You just tell her we were alternates, and she'll just tell you what happened. If not, I want to, again, thank you all for your time and your service, and with our sincere thanks, you're excused from your service. Thank you. All right, court recess. Any exceptions or objections to the instructions as read?
I saw the indictment information type on it.
Okay.
No objection from the defense.
Okay, and I fixed that typo. I'm gonna hand over the instructions. Did you all check the evidence and make sure everything went back?
Yes, Your Honor.
Okay, and the court exhibit's still here?
It's in the locker, Your Honor.
Okay, great. All right, I'm gonna, if y'all would just hold for 1 second and have Mr. Hathaway call the time before you leave and make sure that he has a good contact.